Yes, good afternoon. Thank you for organizing the conference and the opportunity to perform my topic, separate but equal, considerations on the issues of the doctrine of racial segregationism. And also I would like to thank Ms. Miriam Foti for a very extensive introduction to the issue that I'm going to present. And I posted the presentation in the chats. There are only a few photos, but if someone wants to see it, please download the presentation on your laptop. And going to the topic, the issue of racial segregation is very significant and continues to be popular even in the 21st century. One could even say that in the connection with the recent events, as mentioned before, the killing of George Floyd last year by a policeman, the interest in each issue is greater than, for example, 10 years ago. So we can see it on the example of statutory changes in the film production procedures, Oscar procedures, etc. And in my speech, I would like to focus briefly only on the Plessy versus Ferguson case, which initiated the introduction of the separate but equal doctrine. And going to the main topic, what separate but equal was. It was a legal doctrine, a rational policy practiced in some part of the United States by which Afro-American people in some way could be segregated. The basis for this was to create separate places for them equal in quality, but only in theory. For example, places for education, schools and universities, employment places, restaurants, even some part of the roads, etc. And as a short historical disclosure, it's worth pointing out the beginning of the racial politics. After 1877, when control of the southern states was restored, the change of law began. It was mostly targeted at oppressed African Americans based on the principle of segregation, which was unofficially called Jim Crow laws. And mainly it was focused on the creation of separate public administration places. As exception, it is worth mentioning one fundamental inconsistency that the Civil Rights Act had stated that all races were entitled to equal treatment in public accommodations. But unfortunately, later the jurisprudence in this area has diverted and changed its opinion from judgment to judgment. And one of the most critical and essential steps in the legislation procedure was an introduction of the Louisiana Separate Car Act in 1890s. And this act stated that all railroads needs to provide separate accommodations for white and African American passengers. The act made railroads to divide the passenger coaches by partition to secure separate accommodations other than those to which they have been assigned based on their race. And of course, this was strongly criticized because in fact, the places for whites had more facilities, which basically concerned everything that was made for white people in that time. And through getting into this act, it's worth giving an interesting case, which was aimed at showing gaps in the introduced legislation. And undoubtedly, such internal politics forced people to demonstrate illogic systematic loopholes, and the fundamental example is the Homer Plessis case. And he bordered the Homer Plessis case is mentioned because the Mr. Homer aborted a white race unit. In fact, he has mixed race. And he said he was half African American when the conductor verified his ticket. And the conductor said that in this case, he must change the place to for colored. And this action was planned to check what decisions were made, but by that he provided it's hard to define in practice white and colored races because we can't verify this in 100%. And we need to underline that this City Railroad Company cooperated with him because they had to buy a very expensive additional railroad compartment for colored people. And Mr. Plessy was arrested after this action, and later he brought in a case against the state of Louisiana in the district court. His general line of argument was that the state law has denied him his fundamental constitutional rights. But unfortunately, this argument has been refuted and he was sentenced to pay a fine. On his behalf, the Committee of Citizens took Plessy's appeal to the Supreme Court of Louisiana, but no violation of the Constitution was found either. And the famous quote appeared in the justification of the judgment: the prejudice, if it exists, is not created by law and probably can't be changed by law. Human authority ought not to compel these widely separated races to intermix. Of course, such a court-relevant decision caused social rights, and several legal opinions were submitted in support of the Homer Plessy. Even attorneys claimed that the reputation of being black was the property, which implied inferiority of African Americans as compared to white people rights. And the state of Louisiana authorities, however, explained this by the fact that each state has the right to make its own regulations, and this case with railroad doesn't violate constitutional provisions. According to the court, constitutional regulations wasn't intended to give African American social equality, but only political and civil equality with white people. And I would like to give a few sentences from the justification of the court judgment, which seemed to me to be groundbreaking for that time. Legislation is powerless to eradicate racial instincts or to abolish distinctions based upon physical differences. If the civil and political rights of both races be equal, one can be inferior to the other civilly or politically. If one race be inferior to the other socially, the Constitution can't put them upon the same plane. The court concluded that Louisiana law was a reasonable exercise of the state's police power, enacted for the promotion of the public good. In this justification, we see a clear tendency to justify racial segregation. It's worth noting that this has been strongly criticized by representatives of a given legal approach to the problem, and one of the important quotes is, "Our Constitution is colorblind and neither knows nor tolerates clauses among citizens." This statement later influenced a landmark ruling that overturned the entire policy of racial segregation. The ruling strongly emphasized that keeping the distinction between colored and white not only affects the emotional state of race representatives, but also maintains the belief that we can't firmly and brutally separate some people from others, which only results in increased segregation and aggression into society. It's worth noting that this ruling had a great impact on the further course of thought in legal doctrine, but we know from history that the state of segregation has survived even more than half a century. And after this brief analysis, I would like to summarize the most important facts that influence the further course of the historical process. Implementation of the separate but equal doctrine gives a constitutional sanction to laws designed to achieve racial segregation by means of separate and equal public facilities and services for African Americans and white people. Also, in principle, the doctrine provided for the separation of public places, means of transfer, public schools, roads, as I mentioned before, and there was a clear tendency to tolerate African Americans even worse than in theory. This trend persisted until 1954, when the ruling on higher education broke the historical and national barrier to future changes. And thank you for your attention.